Hi, everyone. Thanks so much for joining. So I'm gonna go through the slides and we can go ahead and get started. So the first thing to understand with immigration law is that the sources of law vary. It's different from, let's say, criminal law, where you tend to just look at the penal code and the California criminal jury instructions. Here, we're looking at a variety of sources. Most importantly, we have the Immigration and Nationality Act. That's tends to be our starting point. Then we look at Code of Federal Regulations. We have policy manuals for a lot of the individual agencies. And then, of course, we have case law that comes from a variety of sources. It comes from the Supreme Court, the Circuit Courts of Appeals, and also Board of Immigration Appeals. So there are certain areas of law where there may be circuit splits. So that's why it is difficult when it comes to crimmigration to advise people that may live in a different circuit or in a different state. But that's something to be aware of, is you need to know what circuit you are in to be able to determine how your circuit interprets certain criminal statutes. Also, in immigration law, there's a variety of agencies that you have to be aware of. So we have the Department of Justice, where we have EOIR, or the Executive Office for Immigration Review. So this is normally what people refer to as immigration court. For people that are in removal proceedings, they would have proceedings under EOIR. If they are appealing a decision from an immigration judge, they would be appealing to the Board of Immigration Appeals. Aside from that, we also have a couple other agencies under the Department of Homeland Security. So notably, we have USCIS. So a lot of our clients will actually have pending applications or petitions under USCIS jurisdiction. If someone has a case under EOIR and they file a case with USCIS, you have to determine whether USCIS does have jurisdiction to adjudicate an application, things of that nature. Sometimes you file things with EOIR, sometimes you file things with USCIS. So this is where it's important for clients to have documentation of their applications to determine which agency or office is the one adjudicating their applications. We also have Enforcement and Removal Operations, Office of the Principal Legal Advisor, U.S. Customs and Border Protection. We have ICE, of course. And then under USCIS, they have field offices and service centers and their own Board of Administrative Appeals. So for me, I'm in San Luis County. We do not have a local USCIS field office or a local ICE office. Our closest ICE office is in San Joaquin, and our closest USCIS office is in Fresno. So it's important to know what county you're in and where the regional offices are near you, because that can have an impact in your cases, specifically with clients who may be having cases in criminal court. You want to know where the nearest ICE center is at, and if they do have petitions, knowing, what field office is adjudicating them, etc. So forms of immigration relief, it varies, and there sometimes is confusion on what exactly a person is applying for. And to be honest, it's quite difficult to ascertain without documentation. But some of the basic programs that people are more familiar with. So adjustment of status, that is a way that people may be able to obtain a status as a legal permanent resident. Then we have asylum, Convention Against Torture, deferral of removal, and withholding of removal. Normally, people are in EOIR proceedings for these sorts of relief, but asylum, for example, is one of the types of relief that you could apply for affirmatively within USCIS. So even if you're not in removal proceedings, you could file your petition with USCIS instead of EOIR. So it's just one of those applications where you really need the documentation to know exactly who's adjudicating it. Another version or another way that a person can get legal permanent resident status is through a family petition through consular processing. So the difference between consular processing and adjustment of status is really just where the person has to go do their interview. So adjustment of status is for people who do not have to leave the United States to go do their interview and to have their process adjudicated. Consular processing, people do have to go to the consulate in their country of origin for their interview. One of the big risks with consular processing, of course, is that if your application is denied, you are already out of the country with no way of coming back. So there are a lot of precautions that attorneys have to take when they're working on consular processing cases. Other common applications are U visas, which is for people that have been victims of crime in the United States. T visas, people that have been victims of labor or sex trafficking. Violence Against Women Act, so people who have been abused by a U.S. citizen spouse or parent or adult child. SIJ, which is for special immigrant juvenile status, minors who come into the country by a certain cutoff date, and they're able to pursue some form of status because of their minor status, and also that kind of brings in the dependency system. So you have to have certain family court orders in order to be able to do SIJ. DACA, Deferred Action for Childhood Arrivals. So DACA right now is in a weird spot since they are not adjudicating initial applications. It's mainly just renewals. And then of course we have Texas. This is not doing renewals anymore. So we still have a big population of people that are still under DACA status and getting their renewals every 2 years. We have TPS and NACARA. TPS, if you've been seeing on the news right now, there have been a lot of changes as to TPS status, especially with countries like Venezuela and places like that. The administration has been trying to terminate that status for countries like Venezuela. So there's a lot of ongoing changes at the moment with TPS. Cancellation of removal, you have two types. You have non-LPR cancellation of removal and LPR cancellation of removal. Each of those are ways to fight deportation, essentially, each with their own eligibility criteria. Then we have naturalization, which is when legal permanent residents become U.S. citizens. And then, of course, we have waivers. So all of these applications have different eligibility requirements, and for some of them, there are some waivers that may forgive certain things. There's just too many specifications to really go into how that works, but there are some waivers for certain inadmissibility bars for certain people. So I mentioned how it's really difficult to ascertain exactly what's going on with an immigration case without documentation. And I understand, especially for us that are not working on the immigration case actively, we're working on some other collateral case where immigration just happens to be involved in some way or affected in some way. We are not going to have all of the documentation, right? So it's important to ask your clients what they do have, and if they do have documentation, there are ways that you can review that information. So I included some of the most common documents that clients may have at their disposal. So if they have an employment authorization card, you're able to get a lot of helpful information from that card. If you look at the card and you look under what it says USCIS number, that is what's commonly referred as an A number. So that's an identification number that follows that specific client throughout all of their immigration proceedings. And with that number, you can find out some information, like you can go onto the immigration court website and see if they have an open removal case. Also, on that card, there's a section called category. So on the sample that I included right here, it has category C09. You can plug that into Google and put, US EAD categories, and it'll show you a whole list of the different categories of employment authorization documents. And that often is able to tell you, how did that person get the employment authorization document? Did they get it through a pending asylum? Did they get it through DACA? Non-LPR cancellation or removal, etc. You'll be able to find out what was the basis for them getting that employment authorization document, which could be very helpful for your case. If we look at the permanent resident card, some important information on that card is when they became a resident. So it'll say resident since that can become really important, especially in criminal advisements, because when they become a resident, it can change when they are in danger of triggering certain deportability bars. So that date is really important. Card expires. That will also tell you when they're up to do their next renewal. And if they have open criminal cases, you want to make sure that you figure out if those potential convictions could impact their LPR status and like how risky it would be for them to file a renewal, etc. And also that card also has a category section and a USCIS number. And for categories for LPR cards, it's the same. You could Google it. You just have to Google like LPR categories because those are different than the EAD categories, but they serve the same function. And basically that would tell you how they got their LPR status. So did they get it through a family member? Did they get it as an asylee who was granted adjustment of status, etc. Other important documents, your client may have a notice to appear to appear in immigration court. So you'll be able to find out certain information on that notice to appear, but also their A number and things like that. I-94 is usually for people who cross the border, and CBP will issue them the I-94. So for example, if you come in with a tourist visa, they're going to issue you an I-94. There's going to be a stamp and it's going to say that it was the tourist visa classification. If you're granted parole at the border, that will also show up as on the I-94. So for clients who did enter the country with some form of inspection, they should have an I-94. And if they don't have it on them, like let's say they lost it, there is a website where you could try and pull it electronically. And then finally, we have the Notice of Action I-797C. That is a document that comes from USCIS. So a receipt notice from USCIS, clients will get receipt notices when they apply for certain petitions. So let's say that they are applying for asylum affirmatively through USCIS. They will get a receipt notice saying, you know, we received your application for I-589, which is the form number for asylum. So if they have any of these types of documents, you can go through them and like find out a lot of information just by the type of document that they have. Important websites. So we have the ICE detainee locator, and I included links for all of these websites as well. They're hyperlinks. So the ICE detainee locator is really helpful to figure out where your client is being detained. It is not as helpful in the sense that it's really delayed, especially now. So I've seen clients where, you know, they get detained and it will like automatically let me know where they are in like a couple of days. I've seen others where it's like over a week or 2 weeks. I mean, there's a lot of movement right now within detainees and detention centers, especially since they're opening up all these new facilities. So it's not the most reliable, but if I find out that a client gets detained by immigration, that's always the first place I'm going to go look. If it says that they weren't found, a lot of the times I'm just assuming that it's just a lag in getting updated. So EOIR, automated case information, that is the immigration court website. So with your client's A number, you are able to find out if they are in removal proceedings. Before you only needed the A number, now you do need to know their nationality because you need to plug that information in as well. But if a client has open removal proceedings or at one removal proceedings, or at one point issued a removal order from an immigration judge, or had any form of relief granted by an immigration judge, that information will normally pop up on the automated case information. They also have a phone number that you can call. Like, so if the website is down or it's not working for you or something, there is a phone line that you can call and plug in everything manually, and you'll be able to find the information that way as well. And then the I-94 that I was talking about from CBP, there's that website that you can use to pull it electronically. You do need a lot of information, like you need the client, usually you need the client's passport. So I would ask them to send you a picture of that or get a picture of that before you try and find the I-94. All right, so crimmigration. Traditionally, right, criminal cases were separate and distinct from immigration proceedings, and in a way they still are, but as criminal defense attorneys, we do have a duty to advise our clients about any potential immigration consequences for entering a plea or losing a trial for a specific charge, etc. And obviously, because immigration is so complex and there's so many niches and specializations even within immigration law, it's impossible to expect that, a criminal defense attorney is going to know all of the ins and outs of the immigration system enough to be able to advise their clients. And so immigration attorneys and criminal defense attorneys started working together to figure out, how to advise their non-citizen clients. And we have Padilla v. Kentucky from 2010 that basically said, yes, it is our duty to provide that information to our clients. That was also codified by the California legislature in Penal Code sections 1016.2 and 1016.3. I will note we do have a duty as defense counsel, but district attorneys also have a duty to consider immigration consequences, and that is within those penal code sections as well, if you guys want to take a look at that. So this is just breaking down defense attorneys' duties a little bit more. So like I said, we have 1016.3 in California that says that we shall provide accurate and affirmative advice about immigration consequences. And then we have case law that has informed this duty and told us a little bit more about what we owe to our clients. And it's not just to give them the information, but it's also to try to avoid negative immigration consequences. So it's not enough to say, hey, this could affect your immigration status. You should go talk to an immigration attorney. That's not enough. It's our duty to investigate how it could impact it. It's our duty to tell our clients how it could impact their immigration status. And it's also our duty to try to avoid those negative impacts whenever possible. And we have the California Rule of Professional Conduct that tells us that we fail to act competently if we do not investigate and perform certain duties just because we do not have sufficient skill on our own. It is our duty to seek out someone that does have the expertise and skill that we need to advise our clients. So that is how so many public defenders' offices started contracting immigration attorneys or organizations like ILRC, and now started their own immigration units within public defenders' offices. So what is a criminal conviction under federal immigration law? So juvenile delinquency normally is not considered a conviction for immigration purposes. Diversion. Something that I want to point out that's really important with diversion is not all diversion is equal. We have pre-plea diversion, and then we have deferred entry of judgment. There was a period of time where if you said the word diversion, everybody was like, oh, it's fine, it's going to get dismissed, so there's no issues. The problem is that we had people doing programs where they had to enter pleas up front, and that is still considered a conviction for immigration purposes, even if it is dismissed after the person meets the terms. Why is that? Well, under immigration law, a dismissal for rehabilitative relief is not honored. So things like expungement, 1203.4 expungement, almost never really works for immigration purposes. The immigration law, immigration system, and judges, they will only honor vacatures when they're based on a legal error. If it is simply based on rehabilitative relief, then they will still consider that conviction to be in place. So that's why it's really important to know the type of diversion that your client is going to be entering into, or if they have prior convictions and you're going through their rap sheet and it says diversion, confirm that they didn't enter a plea up front. Especially because in California, we had that period of time where PC 1000 did require a plea up front. Now it no longer does, but there's a period of time where it did. So make sure that when the person entered into that diversion program, they did not enter a plea up front. And if they did, then you can look into post-conviction relief, and we'll talk about that in a second. But it's really important when we're dealing with diversion that we pay attention to that. What kind of diversion was it? And I know it comes up in more counties than others. Like, for example, in my county, our DA's office was doing deferred entry of judgment or deferred sentencing. People call it a whole bunch of different things. The way I look at it, that makes it easier in my brain is, did they enter a plea up front or not? I don't care if you call it deferred entry of judgment, deferred sentencing, diversion. Like, all I care about is, was a plea entered or not? That's what's important when it comes to immigration consequences. So let's talk about inadmissibility versus deportability. When you talk to your Padilla attorney or an attorney from ILRC or any other immigration attorney that you have contracted with to figure out your client's immigration consequences, they need to determine whether the offense that they're looking at is going to trigger any inadmissibility bars and or deportability bars. And how big of a deal, how significant that is for that specific client will depend on their individual circumstances. So, seeking admission, it means a lawful entry into the country. It means that you were inspected by an immigration officer and you were allowed to enter the country. When you are trying to become a legal permanent resident, let's say, for example, you are in the United States, you entered with a tourist visa, you overstayed, you made a life here, you had a child who now turned 21 and wants to petition for you, and so now you're seeking adjustment of status. So it is considered to be seeking admission. Right? You want to become a legal permanent resident. And so now when you become a legal permanent resident, you've been admitted. And once you've been admitted, the things that you have to worry about is not losing your green card, not triggering deportability, right? That's a scenario for one type of person. But now let's say a person who entered the United States EWI, entry without inspection. So they were never inspected at the border. They were able to cross the border. They were never detained. They're here in the United States. And now they picked up a DUI or, some conviction, and they want to figure out how is that going to impact them. Well, they haven't been admitted, right? And so the things that they are worried about are not triggering inadmissibility. So this is a very individualized decision, and whether your client is concerned about inadmissibility versus deportability and how that impacts them will rely heavily on the manner of entry into the United States. So a lot of the times it's not as simple as looking up information about a specific charge and saying, well, like, this is not an aggravated felony, so that's good. So I think we should be good to go. It's not that simple, right? Like, what an aggravated felony is a deportability bar. So how would triggering a deportability bar impact your specific client? These are the things you kind of have to decide before you determine what the effects of that specific criminal conviction could have. So let's look at the criminal grounds of inadmissibility. They are in Immigration Nationality Act, Section 212. So as you can see on the list, drug offenses, reason to believe that the person participated in drug trafficking, human trafficking, or money laundering. This specific section does not actually require a conviction. It can be triggered by your client's own statements to immigration officials, even if, let's say, you got them a really good deal that ended up with the drug sales charge being dismissed. So that's something to be mindful of. Engaged in prostitution, engaging in serious criminal activity where the person has asserted immunity from prosecution, stuff to do with like violations of religious freedom. 2 or more convictions where the total aggregate sentence imposed is at least 5 years. So this is like people who've had multiple criminal convictions. You start looking at the rap sheet, adding up the amount of time that they have aggregated in sentences over time. Um, Also, crimes of moral turpitude, I think this is one of the big ones that we hear about a lot. So how does conviction for a crime of moral turpitude impact a person? Well, it's going to depend. Are they a person who has not been admitted into the United States and we're just trying to preserve their eligibility for potential future LPR status or status or some other form of immigration relief, like non-LPR cancellation of removal or U visa, etc. So the CIMT grounds are very specific in that we have exceptions, but they are very limited. And in a second, I'll show you the CIMT grounds for deportability because CIMT grounds trigger deportability and inadmissibility, but in different ways. So other inadmissibility bars, we have health-related grounds. So this is a big one for people that are doing consular processing and alcohol-related offenses, DUIs, especially multiple DUIs. That can become an issue for people when they go to their interview at the consulate because they are sent to see a government-appointed doctor to do a physical, and that can sometimes bring up the health-related grounds of inadmissibility. Fraud and misrepresentation, false claim to U.S. citizenship, public charge. That's one of the big ones that we hear about a lot, but it doesn't always come into the vein of what we do. But, certain government benefits and things like that, whether people are allowed to receive certain types of benefits. Then we have unlawful presence, and these are all client specific. It's going to depend on when did they enter the country, how did they enter the country, have they ever left the country? You really have to do like a breakdown of all of their entrances and exits into the United States to be able to decipher that. Failure to attend removal proceedings, prior removals. Something that I do want to point out is we tend to just say removal order, not realizing that it is considered, a term of art. We can have different ways that people are removed from the country that didn't necessarily mean they got a removal order. For example, they could have been granted a voluntary departure. Or they could have been been issued a removal order by an immigration judge at the conclusion of their deportation proceedings, or they could have been issued an expedited removal order at the border, things like that, right? So sometimes clients will tell you like, oh, well, I was deported. That requires some more digging when you're working on their immigration case, because you want to figure out what was the legal mechanism by which they were removed from the country. So, deportability grounds. So like I said, this is for people who have lawfully been admitted into the United States, so legal permanent residents. They are not considered to be seeking admission, even if they're traveling internationally and coming back, they're not considered to be seeking admission. So in that sense, they're not subject to the inadmissibility grounds. But like always, there are exceptions to that rule. So for example, let's say that somebody is an LPR, they are convicted of a crime of moral turpitude, and then they didn't trigger deportability grounds because, and you'll see in a second, but they didn't trigger the CIMT deportability grounds, but they were convicted of a crime of moral turpitude. And then they travel outside of the United States and they come back, they get detained by CBP, and they reinstate or they start removal proceedings for the person. How could that happen? Well, there's one exception that says that a legal permanent resident will be considered to be seeking admission if they commit a criminal offense identified in INA 212 A2, which is the inadmissibility bars. So here is how you see how inadmissibility bars and deportability bars, even though they are two separate, distinct bars, they still coexist and can impact each other. And that's why it's so important when you are working with your clients for them to have an individualized consultation, or whether your office has pre-made intakes or whatever it may be, because everything is really, really client specific. So what are the grounds of deportability for the criminal grounds of deportability? So drug convictions again, drug abuse, aggravated felony. You may notice that aggravated felonies were not on the list of inadmissibility bars, but they are a ground of deportability. Firearms convictions, domestic violence convictions, stalking, crime of child abuse, child neglect, child abandonment, civil criminal court finding of a violation of a domestic violence stay away order, uh, miscellaneous crimes like treason, etc., crime of moral turpitude. So these are both grounds of deportability and inadmissibility, but they are slightly different. So the deportability CIMT grounds basically say you are deportable if you have received 2 or more CIMT convictions since you were admitted into the country. So for LPRs, the date of admission would be the day that they became LPRs. Or within 5 years of admission if there was a potential sentence of 1 year. So that's why it's really important to figure out, when did your client become an LPR, right? Did they commit this conviction within those 5 years or after those 5 years? Another thing you'll notice is that the CIMT deportability grounds do not have the petty offense and the youth offender exception. And then a couple more grounds: federal conviction for high-speed flight, failure to register as a sex offender, that's a federal conviction. And then we talked about, I kind of already went through this, but basically, you could lose your green card if you are convicted of a deportable offense, or if you are traveling outside of the United States after having committed one of the inadmissibility crime grounds. Aggravated felonies. So even though aggravated felonies are technically not inadmissibility bars, they are still really important, even for people that are not considered to fall under the deportability grounds, because it can make them ineligible for other forms of relief. So what are aggravated felonies? We have a list, and the way I think of it is there's 2 types. There's one section of the list that it doesn't matter what the sentence is. It doesn't matter if they were sentenced to 1 day in jail. That is automatically an aggravated felony. And then the second column is offenses where their sentence does have to reach 365 days or more. So when you're trying to determine whether the client will possibly trigger an aggravated felony, you want to know, which camp do you fall in? Is it the camp where a single day of a sentence would be an issue, or the one where you just want to avoid getting to 365 days? That's important for clients with cases also because of violations of probation. Sometimes you could have a person who pleads to something that is not an aggravated felony up front based on their sentence, but if they commit violations of probation and that adds time to their sentence, it can become an aggravated felony. So I think it's really important for practitioners to remember violations of probation are also important. I think there was a period of time where people thought, well, it's a VOP, it's not a big deal. But I always tell the people in my office, you need to confirm your client's immigration status for all cases, even if it's a violation of probation, and, do a workup for them, even if it's a VOP. So CIMTs, we talked about those a lot. What is a CIMT? We have a little bit of guidance from case law, but to be honest, it's really amorphous term. And it really has just ended up being like one of those things where we're looking to the circuits and we're looking to BIA opinions and trying to figure out how people are landing on things. But some of the factors that we look at on offenses, specifically the elements, is, what was the mental state required? Was it specific intent, deliberate, willful, reckless, or was it negligence? What was the intent to commit fraud, or to have malice as an element, etc. Like, you're really having to break down each offense and figure out like what was the mens rea of the offense, and that kind of helps guide the CIMT analysis. So, and before we move on to detention, something I want to say, right? Like these are, words that are getting thrown around like murder, rape, burglary. But what does that really mean, right? Like how do we know that California Penal Code 459 is what the federal government considers to be burglary? That's a whole involved analysis called the categorical approach. We also have the modified categorical approach. That is very complex and convoluted, so I'm not going to get into it today. But it's not just as simple, like if you see the word murder, you automatically assume, well, I mean, murder probably, but like it's not automatic. Like if you see the word burglary, you automatically assume that it would be an aggravated felony. Like there is a legal analysis that has to happen with criminal convictions and the elements and, you know, case law and generic definitions of things to be able to determine, is it something that would qualify under the eyes of federal immigration law? So detention. We have seen a shift in detention patterns. We have much more detentions from ICE internally within the US as opposed to CBP at the border. I just included a screenshot of the chart on this website, Track Immigration, so you guys can like go look at it yourselves, but you can see that shift in the switch that we've had where we're seeing much more detentions by ICE as opposed to CBP. So before, when we talked about mandatory detention and, you know, at least for my immigration consultations, it used to be like, let me look at the person's criminal history, let me determine if they've been admitted or not, and let me try to do my best to avoid triggering any of these mandatory detention grounds, just in case, you know, they are detained by immigration officials. They won't be subject to mandatory detention in a detention center. Now, well, earlier this year, we had the Lake and Riley Act, the act that also expanded mandatory detention under INA 236 quite broadly. I mean, Lake and Riley Act, you don't even need a conviction, like an arrest for shoplifting is enough. So the Lake and Riley Act really expanded this ground. It was quite detrimental to our clients. And at the time, I didn't really gauge how we were going to be in a position where now the Lake and Riley Act kind of feels meaningless. And I'll talk about that in a second. So we had a case, matter of Yahuri Hurtado, that just dropped like a week ago. That this is from the Board of Immigration Appeals. It's probably not the end of the road. I'm sure people are going to try to appeal this to circuit courts, etc. But basically, they said that any person that enters the United States without inspection is subject to mandatory detention per INA 235. So, basically, what they're saying is it no longer matters, let me go back, if you've triggered one of the criminal grounds or if you've triggered one of the grounds under the Lake and Riley Act. If you entered iwi, you are automatically subject to mandatory detention in a detention center. They said that immigration judges did not have the jurisdiction or authority to grant bond. Basically, what that means is that the person would have to be in detention indefinitely while litigating their removal proceedings. And if you worked in immigration law, you know that this could take years, months, like it's impossible to know sometimes. And it really feels like the purpose of it is to force people to give up on their claims because they don't want to be stuck in a detention center for an indefinite period of time. Some people have talked about filing habeas petitions in court as a way of trying to get their clients released and get bond for them. Another way is for them to get granted parole, but parole would have to be granted by DHS, so that seems unlikely. So this is a pretty new recent case. We still don't know exactly how it's going to pan out. But in my mind, it kind of just made the Lake and Riley Act be kind of worthless because if they're subject to mandatory detention, just all the time, then why does it matter if I get arrested for shoplifting, like, and they trigger mandatory detention under INA 236? They already triggered it under INA 235, according to the BIA. So, yeah, it's just one of those things where it was kind of confounding how they made it to this holding. Another thing that we've seen is increased agreements between local law enforcement and federal immigration authorities. We have not seen that in California because we have SB 54 not allowing that, and we'll talk about that in a second. And then we had the rescission of the protected spaces policy. So now, immigration authorities are going to courthouses and hospitals and schools and things like that. Um, so it was clear from their memo that they are probably going to be focusing on jurisdictions that have these quote unquote sanctuary city policies. I know that's the term that people use. In California, we have the Values Act, or SB 54. So this is all from their own memorandum that they issued in January of this year. They said that when it came to courthouse operations, they were going to be targeting national or public safety threats, specific non-citizens with criminal convictions, gang members, non-citizens that had removal orders but failed to depart or re-entered the country illegally after having been removed. They did talk about collateral arrest within that memorandum, and they said that they would be subject to collateral arrest considering the totality of the circumstances, and that it would be a case-by-case analysis. So do with that what you will. I'm not sure that they'd be showing a lot of restraint, in my opinion. So immigration in our courthouses. In the memorandum, it did talk about avoiding any areas that were not considered public areas, and to avoid utilizing any non-public entrances and exits without coordination with the courthouse. So of course, in California, there's additional restrictions to that. They also talked about avoiding areas that are generally non-criminal proceedings. So that includes family court, small claims court, traffic court, I imagine, things like that. They do require supervisor approval if they're going to be targeting those types of areas. So under California, SB 54, Truth Act, Values Act, all of that, the courthouses in our state do have the expectation to have model policies that are guided by the California Attorney General about what to do in these sorts of situations. So the courts shall identify non-public restricted locations within court facilities. Personnel shall be trained that not all subpoenas require immediate compliance. Personnel shall not provide personal information to any person for immigration enforcement purposes unless the information is public already or there is a valid judicial warrant. Personnel shall not use immigration authorities as interpreters when an interpreter is necessary to conduct the court's business. So if you look up the model policies issued by the California Attorney General, they have a list of them, and then you can contact your own superior court and ask them what the model policies are within your court. For our court, I asked for those model policies, and they just essentially followed the language of the policies issued by the AG's office. Immigration in our courthouses. So it's important to note that immigration officials can be in uniform, but they can also be in plain clothes, in marked or unmarked cars. They could come in to courtrooms pretending to be a member of the public. They could hang out outside of the courthouse, in the courthouse hallways. Our courthouse used to have live stream proceedings that we have since shut down. So before, they theoretically could watch the proceedings from another place and try to figure out enough information to pull from Odyssey or like these court management systems. I think it's really, really important if you see someone in your courthouse that is suspicious, that you think they might be immigration officials, before you send out an alert to everyone in your office, you should be verifying that they are indeed immigration officials. So how can you do that? My best advice is to go to the bailiffs at the front that are, running the metal detectors and everything and ask them. We have had immigration officials come to our courthouse a couple of times this year, and all of those times we've been able to confirm that they were indeed immigration officials by going to the bailiffs at the front of the metal detectors and just saying like, hey, I just want to confirm, is immigration here in the courthouse today? Are they those people in plain clothes? Did they identify themselves to you, etc.? And like usually the bailiffs at the front will tell you like, yeah, they told us they were from ICE or whatever, and they didn't tell us anything else. Um, so in our courthouse, we have been lucky enough that the time that they have come, it's been very like targeted. They've usually come with, a specific person in mind that they're looking to arrest, and they arrest that specific person and they leave after that. We haven't seen any collateral arrests. They never tell us who they're looking for though. Like they haven't even told our court staff when they come looking for someone. We have normally just been able to tell based on like what department they decide to stand outside of, and we figure out like, okay, it's probably going to be someone from this specific department. Um, and they have, because they're not allowed to go into like these private spaces, they should not be going into like backup where clients are waiting to be called, or the basement where clients are housed. They should not be allowed to go into any of these areas that are not considered public spaces. So if you do have immigration in your courthouse, you should be able to, monitor that they're not being allowed into these areas that they're not supposed to be in. And if they are, you should be able to question your courthouse and say, hey, did they have a warrant? Or why did you allow them back there? And then I included this language from the Code of Civil Procedure that you could say to a judge if there was a situation in which they came inside of the courtroom. Privacy protocols. So assume that people are going to be around that may want to use information against your client. So make sure that you do not talk about your client's immigration status just out in the open, like in hallways and open court and things like that. Like really try to be mindful about where you're talking about these things and how much you're disclosing. We requested that the live stream be turned off in our courthouse. We also stopped the practice of saying collateral consequences on the record because in our county it had become synonymous with immigration. So, at this point we've like urged the attorneys in our office to use other language that's more general, like we need a continuance for further negotiations or further investigation, etc. If you file a motion that talks about your client's immigration status, just remember that, confidentiality, you have to get your client's consent to include any of that stuff in their motions. And if you are going to include specific information about them, like really decide how much is necessary to achieve what you want for the case, and don't disclose anything more than is necessary. I would file those motions under seal. I would not file them as public motions. And then remember that a person's immigration status is not permitted to be disclosed in open court unless there is a hearing requested by the person seeking disclosure. And that's California Evidence Code 351.4. So another thing, this is all language that I pulled from the AG's memorandum that they issued in December of last year. It's really helpful to have with you just in case, especially for 977 appearances. That bulletin like really talked about how judges should be allowing 977 appearances whenever possible. So if you're having a judge that's giving you pushback, I would pull up that model policy and bring that up. So California Truth Acts, SB 54, basically, immigration authorities are really limited in what they can do in our jails. Our jails cannot just hold our client and say like, oh yeah, I'm gonna hold you an extra day so that immigration can come and get you. For example, like in our county, ICE is in San Joaquin, not in Stanislaus County, at least our offices. So it takes them at least an hour to drive over to detain someone from our jail. If they don't feel like coming that day because it's a Friday at 4:30, then the jail can't be like, oh yeah, I'm just gonna hold you until Monday so they can come grab you. They're not allowed to do that. That's a violation of SB 54. Even if a person has an immigration hold or a detainer request or whatever on the jail screen, they're still not allowed to do that. Another thing that I've seen judges want to do is to not grant OR for people because there's an immigration hold on the jail screen. That's not allowed. That's a violation of SB 54. So just remember, there's no exception to that. It doesn't matter what the person is convicted of. There's absolutely no exception to that. The only thing that law enforcement and, the jail staff can do is inform immigration of a person's release date, and that's if they meet an exception. It's not just all the time. But besides that, they can never honor a hold request. So, a thing that we see in our county, when a person is detained and immigration sends the jail a detainer request, they will put the hold or the INS hold on our jail screen. And once I see that an INS hold is on the jail screen, I'm able to request the documents that immigration sent over to the jail. And I'm entitled to them as the person's attorney. I work at the public defender's office, so any of the cases within the PD's office, I'm entitled to that documentation. It may take a little bit of pushback to be able to get the jail to release that stuff to you, but under the law, under SB 54, you are entitled to those documents. And when you get those documents, it will often include like the detainer request, a warrant. It's usually an administrative warrant, not a judicial warrant. And then you're able to pull like your client's A number and a lot of really important information from there. And sometimes a strategy that we take when someone has an immigration hold is to plea them once their credit time served to give immigration less time to be able to come over to our jail and detain them. So this is what it looks like on our jail screen when they have a hold. Obviously, for every county, it's going to be different, but I just want to give you an example of that. Here are these other statutes that have come about through advocacy from immigration rights groups in California, but basically making the maximum for misdemeanors 364 instead of 365 days. That's really important for certain aggravated felonies. PC 1000, making it pre-plea diversion instead of post-plea diversion. And then we have PC 372.5, which is a offense that we could use to negotiate we use it a lot for drug offenses, but it's not just restricted to that. So what do you do when things go wrong? So what if someone has a conviction that, is triggering one of these grounds of inadmissibility or deportability? So you could look into post-conviction relief. In California, we have Penal Code Section 1473.7. This does not require a showing of IAC. It only requires the client not have understood the immigration consequences of their plea at the time of the plea, and it is a subjective test. And there's a lot of good case law about that. So even if the person was advised, but like let's say for example they were going through mental health issues or something like that, and you have documentation to prove that up, and that was the basis why they didn't understand, or you argue that that's the basis why they didn't understand, you could get a vacatur based on that. Then we have 1018, which is usually within 6 months of a plea. And then 1016.5, which is when the court isn't giving the immigration advisement that they're supposed to give on the record when anyone enters a plea. And then we have the Racial Justice Act, which you can use in combination with 1473.7 when you're having, a difficult time negotiating immigration consequences on a vacatur, but also on open cases, like let's say, the district attorney isn't complying by their duty to consider immigration consequences. Racial Justice Act has a section about national origin, so you may be able to make an argument based on that. And then I listed 1203.4 expungement, but again, remember, expungement based on rehabilitative relief is not honored for immigration purposes unless it's for DACA. DACA's a little bit different. So that was a lot of information. One thing I did want to say, I didn't go into specifics as to like what the rules are for DACA and asylum and things like that. Those things are much more specific, and it would require a lot more time to go through all those things. This is just really general information, basic framework. And I'm looking on the chat.
I think
Okay.
I think folks are using the Q&A if you're able to click that button. And if there's anything that we are not able to answer before we end today, I'll put our trainings email in the chat and we can forward any questions that we don't get to you, Karen, if that's all right.
So a couple things that I'm seeing. If a person wants to file post-conviction relief, something that most people don't know is if they file in pro per and they ask for counsel to be represented, the courts will appoint the public defender's office. So that's good to know for people that cannot afford a private immigration attorney to do post-conviction relief. Um, Expungements for LPR clients, like the way that I look at expungement is like it's more mitigating for people as opposed to like actually getting rid of the convictions. So LPR clients who want to become citizens need to show that they're a person of good moral character. And so obviously if they have convictions that did not trigger a ground of deportability or anything like that, and they just want to show that they have good moral character, so they want to show that they got everything expunged because they did really good on probation and did everything that they did. Like that's mitigating. That could certainly be a factor that would go into like helping demonstrate good moral character, but it wouldn't be getting rid of the convictions. And sorry, that question was about LPRs and whether doing filing expungements for them made sense.